संविधान पीठ जो सर्वोच्च न्यायालय में, जो सुप्रीम कोर्ट में हमें मिलता है, वो कई बार संविधान को इंटरप्रेट करने लगते हैं। जो हम आज के दिन असेसमेंट कर रहे हैं वो भी असेसमेंट करते हैं। जब मुद्दे संविधान पीठ को सुप्रीम कोर्ट में मिलता है, हाई कोर्ट्स में मिलता है, उन दिनों में सबसे पहली चैलेंज डॉक्टर B.R. अम्बेडकर ने जो संविधान बनाए थे आर्टिकल 15 में, वो चैलेंज सुप्रीम कोर्ट से ही मिला था। उन्होंने ये करार किया था कि जो एडमिशन में जो रिजर्वेशन मिलता है जो एजुकेशनल इंस्टीट्यूशन में, उन्होंने उसको सेट असाइड कर दिया। चंपकम दराय राजन नाम के केस में सो बाबा साहब अम्बेडकर बहुत ही नाराज हुए, बहुत ही गुस्से हुए। उन्होंने जब अमेंडमेंट मूव किया था, द फर्स्ट एवर अमेंडमेंट टू कॉन्स्टिट्यूशन, सबसे पहली अमेंडमेंट उन्होंने मूव किया था।
नमो तस्सा भगवतो अरहतो सम्मा संबुद्धस्सा बुद्धं शरणं गच्छामि धम्मं शरणं गच्छामि संघं शरणं गच्छामि पाणातिपाता वेरमणि सिक्खापदं समादियामि अदिन्नादाना वेरमणि सिक्खापदं समादियामि कामेषु मिच्छाचारा वेरमणि सिक्खापदं समादियामि मुसावादा वेरमणि सिक्खापदं समादियामि सुरामेरया मज्जपमादट्ठाना वेरमणि सिक्खापदं समादियामि। साधु साधु साधु।
भारतीय संविधान के 75 वर्षों के दौरान सामाजिक और आर्थिक न्याय का जो असेसमेंट है उस पे हम बैठे हैं कि इस राष्ट्रीय सम्मेलन में भारतीय संविधान में पिछले 75 वर्षों में जो सामाजिक आर्थिक न्याय की दिशा में जो प्रयास हुए उसका एक आकलन करने में हम सब लोग एक राष्ट्रीय सम्मेलन आयोजित कर रहे हैं सेंटर फॉर दलित स्टडीज़ की ओर से। और इसमें बहुत से भागीदार संगठन हैं, उनमें रोजा लक्समबर्ग स्टीफटंग साउथ एशिया का एक फाउंडेशन है, इंडियन इंस्टीट्यूट ऑफ दलित स्टडीज़, सेंटर फॉर दलित स्टडीज़, सेंटर फॉर दलित राइट्स, नेशनल अलायंस फॉर सोशल जस्टिस, दलित कोलेशन, पीपल्स कैंपेन फॉर सोशियो-इकोनॉमिक इक्विटी, दलित बहुजन फ्रंट। तो ये जो तमाम भागीदार संगठन हैं, इन सब के सौजन्य से, इनके सबके मार्गदर्शन में आज का ये राष्ट्रीय सम्मेलन हो रहा है। आप सबका स्वागत है इस राष्ट्रीय सम्मेलन में। मैं सुखदेव विश्व प्रेमी हिमाचल प्रदेश से हूँ। पीपल्स कैंपेन फॉर सोशियो इकोनॉमिक इक्विटी के नाम से एक अभियान 2007 में शुरू हुआ था, उसका प्रतिनिधि हूँ और वहाँ एक स्टेट कोलेशन है, स्टेट कोलेशन फॉर लेजिस्लेशन ऑफ शेड्यूल कास्ट शेड्यूल ट्राइब सब प्लान के लिए एक आदरणीय लक्ष्मैया जी के मार्गदर्शन में एक कैंपेन शुरू किया है, उसका मेंबर हूँ।
We are celebrating 75 years independence of Republic Day. This is a journey of 75 years Indian Republic functioning. Before this, we erecting miniature of the Samvidhan Stamp in 6th floor. We are going to have a developed museum in the 6th floor. In that we started. Now we are going to have a established in 20 feet, but today we put in miniature. The Samvidhan Stamp is a very important. We thought this is the journey of Indian democracy. Indian democracy started not now, not in independent movement, not in something 1000 years. It was started from 2600 years with the Gautama Buddha. That's why we thought every village and every mohalla, whoever they aspiring, whoever they practicing, whoever they wishing the democratic country, that mohalla, that basti should have this Samvidhan Stamp. This Samvidhan Stamp should actually, this is the original of Ashoka Stamba, Ashoka pillar, but we developed 4 comments of democracy, welfare of the people, and fraternity, and Indian Constitution, heart of Indian Constitution, of a preamble. In that, I think this is one thing today we did it. Another thing is today, why? Because we are celebrating this today is a very important, the milestone of Indian democracy, milestone of Indian history also. The 75 years we traveled with our constitution. With the constitution, we got so many victories, so many rights we got, so many welfare schemes came, so much relief to the victims, whoever they exploited by the rich and upper caste and feudal people. In that context, in this time, we have so many obstacles, so many problems for the constitution with the rulers and activists, so many people. They are talking against the constitution, they want to change the constitution, so many things they are talking. That's why this group, now we announced the names. With that groups, we are organizing every week online seminar. With the friend Rajshekar Undru suggestion, we going to organize 75 online lectures from November 26, 2024 to November 26, 2025.
I have a feeling that this is going in the future. This is going to be a central place where the research on Dalit and related issues will be taken. It is always difficult for us to build up an infrastructure. We require physical infrastructure and human resource infrastructure also, but physical infrastructure is very difficult, and I think because of his leadership and effort, we have this 9-story building with different floors, and definitely in future this will turn out to be a major center of Dalit think tanks. Given the time constraint, I will only make a couple of points because there are many speakers and time is much less. We all are concerned and deeply depressed at time, the kind of the situation that is going on around. never before in the history of India the constitution has been brought into such a central stage, and everybody want to grab it. The reason is that the people think that the constitution is itself is under risk, and therefore it has to be reminded, it has to be celebrated that constitution is close to our heart. Constitution is, as a matter of fact, the instrument of liberation of India and in general, and the depressed classes in particular. It is in the present context, I just want to make a couple of points for your consideration. The topic that I have selected for discussion is emancipatory element in Indian Constitution, and how the vision of Dr. Babasaheb Ambedkar is not fully incorporated into this constitution. His idea of constitution is, he was successful in bringing several of his thoughts in the constitution as the chairman of the drafting committee, but at the same time, his thought and his original thoughts about the constitution, what constitution we should have. Will you please stop for a minute, please? You can sit down and take the photograph later on because it gets disturbed. So although we say that the Constitution, Baba Sahib is the framer of the Constitution, he is the architect of the Constitution, but not all of his thoughts are included in the Constitution. And that is very important. And secondly, that for not being included in his thought in the Constitution, the danger that we are confronting today, as far as the Constitution is concerned, it is because that his views were not incorporated. We have a very distinguished justice here, Sudarshan Reddy, Sri Sudarshan Reddy. He will say in greater detail. But the limited point that I want to make is this: that Dr. Babasaheb Ambedkar was able to bring many principles in the Constitution which emancipate the Dalit, emancipate the depressed classes, transform their life. In Hindi, we say that the Constitution is sort of mukti. It brings a mukti and freedom to the depressed classes. And there are several elements in the Constitutions. I remember to have commented on the lecture given by Justice Chandrachud, former Chief Justice Chandrachud, on his lecture in Brandeis University, USA. The emancipatory element in the institution, in the Indian Constitution, has a two-part. One is, of course, the preamble, which define the character of the Constitution, it being democratic, secular, socialist, and republic. And the goal of the Constitution is to provide social justice, equality, liberty, and fraternity, and also national integration. This is the major part of the Constitution, but the core of the Constitution is the fundamental rights. Fundamental rights of any constitution is the core of the Constitution. Executive, judiciary, and several other things are for the purpose of ensuring fundamental right to the people. And the fundamental rights, of course, are equality, equal opportunity, equality before law, liberty, freedom, and freedom of all kinds, freedom of religion, freedom of expression, freedom of writings, and the fraternity, the brotherhood between the people. So this is the core of the Constitution that Baba Sahib has brought, and the Constituent Assembly has brought. Article 16, Article 14 talks about equality. Article 15 talks about non-discrimination, that nobody will be discriminated based on his or her identity of caste, religion, ethnicity, gender. And Baba Sahib brought additionally this emphasis on non-discrimination. Equality was good enough, but he reiterated the non-discrimination as such. Now, this is the core of the Constitution, that fundamental rights are given. Constitution ensures those fundamental rights. State has a responsibility to guarantee the fundamental right. Now, this has been the part of the Constitution everywhere. The British Constitution that we have taken from and elsewhere. But what is additional in Indian Constitution, and primarily because of Dr. Babasaheb Ambedkar and also by the Constitutional Assembly, is that the commitment on the part of the state to do something to promote fundamental rights, and particularly for the depressed classes. Constitution would have been good enough to say that we guarantee this fundamental right. But I think Dr. Babasaheb Ambedkar, if you remember correctly, his comment on the objective resolution presented by Jawaharlal Nehru, and he said that this objective resolution talk about equality, social justice, but I don't see remedies. And fundamental right without remedies have no meaning. So Babasaheb Ambedkar went a step ahead. And in this constitution, the aspect of emancipation, aspect of transformation is that there are certain remedies in the constitution, which I think is the contribution of Babasaheb Ambedkar.
ఇవాళ మన భారతదేశంలో ఒక విచిత్రమైన పరిస్థితి ఉంది. పాలకులకేమో ఈ రాజ్యాంగం పోతే బాగుండు, ఇది బంగాళాఖాతంలో కలిపేస్తే బాగుండు అనుకుంటున్నారు. ప్రజలేమో కంచుకోటలాగా నిలబడి రాజ్యాంగాన్ని కాపాడుకునే ప్రయత్నం చేస్తున్నారు. ఇది చాలా ప్రత్యేకమైన పరిస్థితి ఇవాళ మన దేశంలో. పాలకులకు ఎందుకు పోవాలని ఉందంటే, ఇది లేకపోతే ఇంకా వనరులను మనం కొల్లగొట్టచ్చు, దోచుకోవచ్చు, మొత్తం కూడా కొంత కార్పొరేట్ వర్గానికి పంచిపెట్టచ్చు అనే కోరిక ఉంది. ప్రజలకేముందంటే, ఎంతో కొంత ఆత్మగౌరవంతో ఇలా బతకగలుగుతున్నామంటే అది రాజ్యాంగం చేయబట్టే. ఈ రాజ్యాంగమే లేకపోతే మనం ఈ ఆత్మగౌరవంతో బతికే అవకాశం కూడా ఉండదు అని ప్రజల్లో ఒక భావన. ఇది చాలా కీలకమైనటువంటి పరిణామం. అందుకనే ఇవాళ పాలకులు రాజ్యాంగాన్ని కెలికినప్పుడల్లా ప్రజలు పెద్ద ఎత్తున తిరుగుబాటు చేస్తున్నారు, రకరకాల రూపాల్లో అసంతృప్తిని వ్యక్తం చేస్తున్నారు. అట్లా ఇది ఒక విస్తృతమైన ప్రజా పునాదిని సంతరించుకున్నది. బహుశా ఇంత ప్రజా పునాది కలిగినటువంటి రాజ్యాంగం చాలా తక్కువగా, చాలా అరుదుగా కనబడుతూ ఉంటుంది. ఇవాళ ప్రజలకు ఎందుకు ఇది ఇంత కీలకమైంది అంటే, మనకు 3వ అధ్యాయం 4వ అధ్యాయం చేయబట్టే. అవి లేకపోతే ఈ రాజ్యాంగానికి ఇతర రాజ్యాంగాలకు తేడా ఉండదు. మన రాజ్యాంగంలో ప్రధానంగా 3వ అధ్యాయం అనేది ప్రజలందరికీ హక్కులను కల్పిస్తున్నది. అది తీసుకొచ్చిన ఒక విప్లవాత్మకమైన పరిణామం ఏంది? ప్రజలందరూ సమానమని ప్రకటించింది. రాజకీయంగా అందరూ సమానులమే, సామాజిక జీవితంలో అందరం సమానులమే అని ప్రకటించింది. దేశంలో ఉన్న అసమానతలను రద్దు చేసింది.
You will forgive me for taking slightly a different route, for ignoring for the present the tagline, assessing the achievements in socio-economic justice. That would be a separate topic. There will be many occasions to speak about in CDS. I propose to deal with one or two recent developments and their impact on the Constitution of India as we understand. And guilty men for my deviation who are responsible is Professor Kodanram and Sri Ramchandramurthy. I was exchanging notes with them to frame my idea. And it is they who are responsible for my deviation. Otherwise, that is my favorite topic, socio-economic justice under the Constitution of India. To the extent possible, I would not repeat what Professor Thoraji and Professor Kodanram said. I don't know. All of you have, I suppose, read it, including the galaxy of distinguished guests sitting here. A lecture delivered by none other than the most powerful person after the Prime Minister of India, Honorable Home Minister of this country. While inaugurating the Hindu Spiritual and Service Fair 2025, organized by RSS affiliate. Its name is Hindu Spiritual and Service Foundation. We don't know how many such foundations we have. The Honorable Home Minister said, I quote exactly what he has said. Several works of our ideology, which no one dared to even touch in the last 7 decades since independence. This was a lecture delivered on the eve of 20th Republic Day. Of course, there is no mention of Republic Day, no mention of Constitution, no mention of Baba Saheb, no mention of Gandhi, no mention of any freedom fighters. It's a separate matter. And today, India is standing before the world with a pride. And he continued, Article 370 has been abrogated in Kashmir. Ram Lalla's exile. We never knew that Ram could be in exile. Is over after 550 years. And a grand Ram temple has been constructed in Ayodhya. Kashi Vishwanath corridor has been made. Somnath temple is being made of gold. Triple talaq is stopped. And the Uniform Civil Code is also in place. This is in continuation of what the head of their organization, Sir Sangchalak, said that Swa is missing. What we got on 15th August 1947 is not the independence. It is 21st January 2024, consecration of the idol of Ram. So what does it mean? Has it anything to do with the ideology of the Constitution? We have a different notion of Constitution and its scope. We always thought it is a revolutionary document, assuring social, political, economic revolution. What is the understanding of such of those who believe in this quote unquote our ideology? What is that our ideology has to do with the Constitution? Constitution is not something which has fallen from the sky. it's not given to us by somebody. It is we, the people, and given it to ourselves. Of course, our founding fathers and mothers, founding mothers, about whom we don't speak, were responsible for shaping that document in which Baba Saheb played a predominant role, and that's how we consider him as architect of the Constitution and rather father of the Constitution. If Gandhiji was the father of nation, Baba Saheb was father of Indian Constitution.
We are celebrating the Indian Republic Day. భారత రాజ్యాంగ దినోత్సవాన్ని ఒక సంబరంగా జరుపుకోవటం అనేది చాలా సంతోషకరమైనటువంటి సందర్భం. భారతదేశంలో ఉన్నటువంటి ప్రజలు ఏదైనా పండుగను బాగా జరుపుకోవాలి అని అంటే ఈ దేశంలో ఉన్న ఒకే ఒక పండుగ, అది భారత రాజ్యాంగం అమల్లోకి వచ్చినటువంటి జనవరి 26, 1950ని గుర్తుపెట్టుకోవాలి. అంతకంటే మించిన పండుగ, అంతకంటే గొప్ప సందర్భము ఈ భారతదేశంలో లేదు. ఎందుకంటే భారతదేశానికి వచ్చినటువంటి ఈ రాజ్యాంగం గతంలో ఉన్నటువంటి రాజ్యాంగాన్ని రిపీల్ చేసి అంతకంటే ముందున్నటువంటి మనుధర్మ శాస్త్రాన్ని రిపీల్ చేస్తూ అసమానతల్ని తొలగిస్తూ సమానత్వాన్ని సాధించడానికి ప్రజలందరికీ సర్వహక్కులు ఇచ్చినటువంటి గొప్ప రాజ్యాంగం భారత రాజ్యాంగం. ఆ దశలో గనక మనం పరిశీలిస్తే నేను ఈ సందర్భంగా ఒక 2 విషయాలు చెప్పి వక్తల్ని ఆహ్వానిస్తాను. ఒకటి, నేను యాక్చువల్గా ఒక పేపర్ ప్రజెంట్ చేయాలనిపించింది. ఎడ్యుకేషన్లో ఉన్నటువంటి అచీవ్మెంట్స్ ఏంటి ఇన్ ద కాంటెక్స్ట్ ఆఫ్ ది ఇండియన్ కాన్స్టిట్యూషన్ అనే విషయంలో. భారత రాజ్యాంగం ఎందుకు అంత గొప్ప పండుగ అంటే, ఒకవేళ భారత రాజ్యాంగం కనుక వచ్చి ఉండకపోయి ఉంటే, బాబాసాహెబ్ అంబేద్కర్ కనుక అంత గొప్ప రాజ్యాంగాన్ని నిర్మించి ఉండకపోయి ఉంటే, మనం అందరం ఇలాంటి కూర్చునే వాళ్ళం కాదు, ఇలాంటి సభలు జరుపుకునే వాళ్ళం కాదు, ఈ పొజిషన్స్ చేసే వాళ్ళం కాదు అని నేను అనుకుంటున్నా. కాబట్టి ఆ కాంటెక్స్ట్లో అది రావడానికి కారణం ఏంటంటే, భారత రాజ్యాంగంలో ఉన్నటువంటి అనేక అంశాలు, అది ప్రియాంబుల్ కావచ్చు, డైరెక్టివ్ ప్రిన్సిపల్స్ కావచ్చు, అనేక రకాల ఆర్టికల్స్ కావచ్చు, అవన్నీ ఏం చేసినాయి, భారత రాజ్యాంగాన్ని రాకంటే ముందు అంటరానితనం అనేది ఆమోదయోగ్యమైనటువంటిది. భారత రాజ్యాంగం వచ్చిన తర్వాత, ఆర్టికల్ 17 వచ్చిన తర్వాత అంటరానితనం అనేది రద్దు చేయబడి అంటరానితనము నేరమని చెప్పగలిగినారు. అలాంటి అనేక సమానత్వానికి సంబంధించినటువంటి ఈ కాంటెక్స్ట్లో ఎడ్యుకేషన్కి సంబంధించినటువంటి అంశాలు కూడా చాలా వచ్చినాయి. అందులో మనం కనుక పరిశీలిస్తే ఇప్పుడున్నటువంటి కాంటెక్స్ట్లో మనందరికీ చాలా ముఖ్యమైనటువంటి అంశం ఎడ్యుకేషన్కి సంబంధించి మనందరికి కూడా ఒక కాన్స్టిట్యూషనల్ ఫౌండేషన్స్ ఉన్నాయి. మనందరికి కూడా అఫర్మేటివ్ పాలసీస్ వచ్చినాయి. ఈ కాన్స్టిట్యూషనల్ ఫౌండేషన్స్, అఫర్మేటివ్ పాలసీసు, ఆర్టికల్స్ అన్నిటిని దృష్టిలో పెట్టుకొని 75 ఏళ్ల ప్రయాణంలో కనుక మనం పరిశీలిస్తే ఏ మేరకు సాధించినాం, ఏ రకమైనటువంటి ఛాలెంజెస్ మనకున్నాయి అనేటువంటిది కనుక చూస్తే, ఇప్పటికీ కొంత భారత రాజ్యాంగం వల్ల చాలామంది చదువుకోగలిగినాం. నాలాంటి వాడు మీ ముందు మాట్లాడుతున్నాడంటే ఆ రోజు భారత రాజ్యాంగం రావటం, భారత రాజ్యాంగంలో పొందుపరిచినటువంటి అనేక సౌకర్యాలు, అది ఎస్టాబ్లిష్మెంట్ ఆఫ్ పబ్లిక్ యూనివర్సిటీస్ కావచ్చు, లేదా హాస్టల్స్ కావచ్చు, రెసిడెన్షియల్ స్కూల్స్ కావచ్చు, స్కాలర్షిప్స్ కావచ్చు, ఫెలోషిప్స్ కావచ్చు, వీటన్నిటి ద్వారా ఎంతో కొంతమంది నాలాంటి వాళ్ళు, మీలాంటి వాళ్ళు ఇంత దూరం ప్రయాణం చేయగలిగి చదువుకొని కొన్ని పొజిషన్ చేయగలుగుతున్నాం. ఛాలెంజ్ ఏంటంటే, ఇంత కాన్స్టిట్యూషనల్ సపోర్ట్ ఫౌండేషన్స్ వచ్చినప్పటికి కూడా భారతదేశంలో రాజ్యాంగం వచ్చిన నాటికి ఉన్నటువంటి GR, గ్రాస్ ఎన్రోల్మెంట్ రేషియోని కనుక చూస్తే దెర్ వాజ్ ఓన్లీ 1% ఆఫ్ GR.
आज का जो विषय है हमारे सामने जो रखा है, बहुत ही महत्वपूर्ण विषय है. 75 साल में हम हर एक मुद्दे पे मुड़ के पीछे देख सकते हैं, क्या हमें पाए क्या खोए 75 सालों में, बट एक संविधान हमारे साथ खड़ा है, हम संविधान के साथ खड़े हैं। मेरा विषय जो आपके सामने, जैसे लिम्बाद्री साहब, जो प्रोफेसर लिम्बाद्री जी आज के इस मंच का चेयर है, उन्होंने ये कहा कि एजुकेशन के बारे में हम कहाँ तक पहुँचे। इस विषय में थोड़ा सा पीछे आपको मैं जो दलित उन दिनों में जो अनटचेबल्स हैं उनके लिए एक स्कॉलरशिप की व्यवस्था मैं आपको उस समय तक ले जाना चाहता हूँ जहाँ 1932 में डॉक्टर B.R. अम्बेडकर ने जो पूना पैक्ट के तहत उन्होंने पहली ये अचीवमेंट करे हैं कि जो ट्रेजरी के ऊपर पहली राइट जो हक जो बनता है वो अनटचेबल्स या डिप्रेस क्लास उन दिनों को कहते हैं, उनके स्कॉलरशिप के लिए। अगर 1932 में जब ये निर्णय हुआ था पूना पैक्ट के तहत, फिर भी ये इम्प्लीमेंट नहीं हो पाया था। 1944 में 1944 में बाबा साहब जब वाइसरॉयज एग्जीक्यूटिव काउंसिल में वो मेंबर थे, उन्होंने वाइसरॉय के सामने जाके कहा कि ये पूना पैक्ट के तहत जब ये निर्णय हो गया था कि एजुकेशन में हमें सुविधाएं प्राप्त होंगे, ये नहीं हो पाया था। तो जो 1942 में 1942 1944 में पहली बार जो स्कॉलरशिप के तहत यहाँ बहुत लोग यहाँ जो पढ़ाई किए, हमारे पिछले जनरेशन में जो पढ़ाई किए, काकी माधवराव साहब, सुखदेव थोराट साहब, जिस स्कॉलरशिप के साथ पोस्ट मैट्रिक स्कॉलरशिप हमारे जो आज के दिन मिला है, वो संविधान से पहले ही हमें हासिल हुआ था। 1944 में उसका नाम था पोस्ट मैट्रिक स्कॉलरशिप। वो आज के दिन में हमें उपलब्ध है। वो बाबा साहब अम्बेडकर के दूरदर्शी उन्हें हमें ये प्राप्त हुआ था। जैसे हम आते हैं, जब संविधान बना था, बाबा साहब ने ये अनुच्छेद 15 आर्टिकल 15 के तहत उन्होंने सोचा था ऑटोमेटिकली हमें दो चीज़ें प्राप्त होंगे। वो एक रिजर्वेशन इन एडमिशन, जब आपको किसी एजुकेशन संस्था में एडमिशन लेना था तो आपको ऑटोमेटिकली मिलेगा, और ऑफ कोर्स दूसरी चीज़ था स्कॉलरशिप। वो उन्होंने डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी में आर्टिकल 46 के तहत उन्होंने बनाए थे। बट सबसे पहली चैलेंज जो कॉन्स्टिट्यूशन को मिला था वो और किसी से नहीं मिला था, सुप्रीम कोर्ट से ही मिला था। कॉन्स्टिट्यूशन के सबसे पहले चैलेंज, क्योंकि ये जो हम 75 साल में पीछे मुड़ के हम आगे क्या करना, पीछे क्या हुआ ये देखते हैं, उसमें हमें कई बार संविधान पीठ जो सर्वोच्च न्यायालय में जो सुप्रीम कोर्ट में हमें मिलता है, वो कई बार संविधान को इंटरप्रेट करने लगते हैं। जो हम आज के दिन असेसमेंट कर रहे हैं वो भी असेसमेंट करते हैं। जब मुद्दे संविधान पीठ को सुप्रीम कोर्ट में मिलता है, हाई कोर्ट्स में मिलता है, उन दिनों में सबसे पहली चैलेंज डॉक्टर B.R. अम्बेडकर ने जो संविधान बने थे आर्टिकल 15 में, वो चैलेंज सुप्रीम कोर्ट से ही मिला था। उन्होंने ये करार किया था कि जो एडमिशन में जो रिजर्वेशन मिलता है जो एजुकेशनल इंस्टीट्यूशन में, उन्होंने उसको सेट असाइड कर दिया था। चंपकम दराय राजन नाम के केस में सो बाबा साहब अम्बेडकर बहुत ही नाराज़ हुए, बहुत ही गुस्से हुए। उन्होंने जब अमेंडमेंट मूव किया था, द फर्स्ट एवर अमेंडमेंट टू कॉन्स्टिट्यूशन, सबसे पहले अमेंडमेंट उन्होंने मूव किया था, वो ऑमनीबस अमेंडमेंट था। उसमें एक अमेंडमेंट ये था कि आर्टिकल 15 को एक सब सेक्शन 4 उन्होंने आर्टिकल 15(4) दिए थे, जिसमें उन्होंने स्पेशल प्रावधान किया था। क्लियरली लिखना पड़ा उनको कि शेड्यूल कास्ट और शेड्यूल ट्राइब्स के लिए एजुकेशनल इंस्टीट्यूशन के रिजर्वेशन के प्रावधान। ये एक प्रोग्रेस है हमारे संविधान में, क्योंकि संविधान में 15 का जो आर्टिकल 15 का जो प्रावधान किया था उसके एक प्रोग्रेस है। तो संविधान हमें ये दिखाता है, अगर हम संविधान के जो हक हमें आगे ले जाना है, वो प्रोविजंस, वो सेक्शंस, जैसे आर्टिकल 15 है, आर्टिकल 16 है, आर्टिकल 335 है एंड आर्टिकल 46 है, जो डायरेक्टिव्स एंड प्रिंसिपल्स में इन हमें आगे ले जाने की एक मौका प्रदान करते हैं। तो हम अगर इसको इसी सेक्शन को आगे ले जाते हैं, कई साल बाद यूपीए सरकार 1 में एक और अमेंडमेंट हुआ था। वो अमेंडमेंट था आर्टिकल 15(5), जिसको कई लोग मंडल 2 के नाम से भी पुकारते हैं, जहाँ सेंट्रल गवर्नमेंट इंस्टीट्यूशंस में रिजर्वेशन, एजुकेशनल इंस्टीट्यूशन में रिजर्वेशन की प्रावधान किया गया था। वो प्रावधान करते हुए हमारा जो पार्लियामेंट उन दिनों का, उन्होंने एक और प्रावधान किया था, जो अभी लिम्बाद्री साहब ने अपना वक्तव्य में बताए थे, कि प्राइवेट एजुकेशनल इंस्टीट्यूशन में अगर कोई स्टेट चाहे, स्टेट या सेंट्रल गवर्नमेंट अगर चाहे, उसमें रिजर्वेशन की प्रावधान क्लियरली आज के दिन संविधान हमें देता है, हमें प्रोवाइड करता है वो जो अवेलेबिलिटी। क्या हम आगे अगर असेसमेंट 75 सालों में हम ये करना चाहेंगे, 75 ईयर्स में असेसमेंट करना चाहेंगे, हमें एक ये आर्टिकल जो 15 जो है, जो बाबा साहब ने पहले अमेंडमेंट ने करके हमें दिए थे, वो आगे हमें एक रास्ता, हमें एक मार्ग क्लियरली दर्शाता है कि हम रिजर्वेशन इन प्राइवेट एजुकेशनल इंस्टीट्यूशन में जा सकते हैं। उनमें ये प्रावधान बहुत ही क्लियरली किया था कि एक्सेप्ट माइनॉरिटी एजुकेशनल इंस्टीट्यूशंस, जो माइनॉरिटीज़ अपना एजुकेशनल इंस्टीट्यूशन बनाते हैं, उनमें रिजर्वेशन का प्रावधान नहीं दिया, बट वो माइनॉरिटी एजुकेशन इसके ऊपर है कि वो दे या ना दे। ये एक क्लियर कट हमें फ्यूचर के लिए एक चैलेंज है। अगर संविधान को हम आगे ले जाना चाहते हैं, उनके प्रोविजंस को अचीव करना चाहते हैं असेसमेंट के बाद, कि आर्टिकल 15(5) में जो हमें अवेलेबल है, आर्टिकल 15(5) बाद में एक और अमेंडमेंट किया था 2014 के बाद, इकोनॉमिकली वीकर सेक्शन नाम का एक समुदाय को भी रिजर्वेशन का प्रावधान उस आर्टिकल में किया गया था, फर्दर अमेंडमेंट करते हुए। मैं ब्रीफली एज असेसमेंट में एक ही मुद्दा आपके सामने आज रखना चाह रहा था, कि ये मुद्दा आपके सामने इसलिए रखा हूँ कि आगे जनरेशन्स के लिए, जैसे लिम्बाद्री साहब ने कहा, 80% एजुकेशनल इंस्टीट्यूशन आज के दिन प्राइवेट सेक्टर में है, तो क्या हम उस हक को अचीव कर पाएंगे, आगे ले जा पाएंगे?
The question of correcting historical injustice in terms of control of resources. So if we speak about it historically, it goes back to 1855 with the Santhal rebellion, and then the Birsa Munda revolt, and then the Bhumkal Andolan in Bastar, all of which was essentially revolved around the question of nationalization of forests by the British, or the feudal system, the zamindari system brought into the tribal areas by the British. So through these revolts that we saw before independence, the British were forced to bring in some laws which essentially said that tribal land cannot be alienated, cannot be transferred to a non-tribal person. So that was the essence of what legal changes that we saw during the British. And then came the Constituent Assembly, and where Jaipal Singh Munda essentially, if you look at what he essentially said, was that in this, when we are coming together to make this country, what he said was that we identify ourselves as being indigenous and we look at everybody else being outside, but now that we are coming together to make this country, we hope and we trust that the Adivasi question will be addressed. And he also did say that now that we are coming to make this country, to make this constitution, this may not be a time to fight and to say that whose interests, and to find that place in the constitution to secure each community's rights. So he completely said, and he reposed full faith in the Constituent Assembly, saying that we putting our faith in the Constituent Assembly and we trust and hope that the Adivasi question will be answered. So when you look at the constitution, firstly there was article 244 in the constitution which spoke about administration in scheduled areas, and you had the fifth schedule, the essence being essentially that uh, in terms of resource control, special provisions could be made for Adivasis. So after that, what we saw after independence was that very few, each state has laws which prevented alienation, but very few regulations were made. And then over and above that, you still had the Land Acquisition Act of 1894 in place, and you had the Coal Bearing Act, you had the Mines and Minerals Act. So what in a sense, what you saw was that uh, the principle of eminent domain was in place, and essentially what it said was no matter what Adivasi rights एक जगह पर हैं, but ultimately the state has ultimate power to acquire land for mining, linear projects, etc. So that struggle continued until the Panchayat Raj amendment that we saw. Then the PESA Act came in 1996 to implement the Panchayat Raj amendment, and in that the Gram Sabha was given powers. However, the different states did not adopt PESA as it is, and in some states they did not make rules like we know. And then from 1996 we come down to 2006, where finally you had the Forest Rights Act being passed by Parliament, and where they said that this act was being brought to correct historical injustice, where people's common resources had been nationalized under the Indian Forest Act. So they said that, and it finally recognized that we are bringing in this law to correct historical injustice and recognize your individual and community forest rights. Now, even after that, so it's been so many laws in place, and then again in 2013 the new Land Acquisition Act came. They made special provision for scheduled areas where they said that you need consent of the Gram Sabha. So they finally got in consent. Now again in that consent clause, however, they kept certain projects outside. They said mining is not included, linear projects like railways, highways is not included. All of that was in place. But essentially the 2006 law was considered to be the strongest because it said that the Gram Sabha has power to control its resources, and that is what the Supreme Court said in the Niyamgiri judgment, that ultimately it is the people who have the power to decide whether or not they accept a particular development project, whether or not they accept land acquisition. So that is how things stand as of now. However, after 2019 certain more changes were made, like mainly coal being the most contentious area, where they have amended the Mines and Minerals Act to say that now a private company, speaking about the model of development in the constitution, they've taken it further to say that a private company can take land and sell coal for profit, not just to produce power, which was earlier limited to electricity. So we've seen where the law has been going, and essentially it is going down the path where it's a full privatization model, where the law has been set clear, where your land can be taken away for that, and the Adivasi communities having had to pay for that. And that is with respect to different laws. So as of now, the law as it stands is the Gram Sabha has powers, but in practice what has happened is that, as far as I know, you wouldn't find a single project where a Gram Sabha consent has taken place properly. I mean, there are cases, courts are flooded with cases with fake Gram Sabha, with misuse of powers. And what we also see is that somehow we got these laws made through the legislature, but when it comes to the executive and the bureaucracy, I mean, there is zero intention or to follow these laws and to actually ensure that protections given to tribal people are implemented. So that is with respect to question of resources. The second thing I was talking about was that when you look at these conflict areas, say for example Bastar or other places, it's a complete suspension of fundamental rights. I mean, there are no two ways about it. Your right to life, the number of extrajudicial killing, the allegations of extrajudicial killings that are taking place, the number of arrests that are taking place, and also the scuttling of any form of democratic protest against militarization that is taking place. It's a complete suspension of fundamental rights in these areas. And when we look to court, I think Justice Reddy was here. The only ray of hope that we saw some time back was in the Salva Judum judgment, wherein the Supreme Court outlawed the Salva Judum, and it spoke highly against violence that is being committed in these areas. After that, in a series of cases, the CBI has filed closure in a large number of extrajudicial killings. So we have really seen no justice when it comes to that. And So that is with respect to suspension of life and liberty under Article 2021 in these areas that we see. And the last part is what we've seen recently is the question of splitting the Adivasi community into, say, the opposition towards the converted Christian tribals was always there. Historically there has been a demand of delisting where they say that tribal Christians should not be given benefits of reservation, etc. But what we've seen now is a weaponization of the PESA, where they're saying that in the name of in the name of protecting tribal custom and culture, there has been this attempt to completely target tribal Christians, and a complete attempt to say that the biggest threat facing the Adivasi community is conversion. So what we're saying now that in villages in Bastar, for example, there is a complete split in the community, and you may have heard of cases where people are not being allowed to bury their people, to bury their Christian people are not being allowed to bury their dead people in the community graveyards, and people are having to go up to the Supreme Court.
People are talking about First Amendment even today in an attempt to blame Nehru for restricting freedom of the press. So that was one of the provisions in the First Amendment. First Amendment was thought of because the courts were acting to the spirit and letter of the Constitution and negating many things that government did. They were not allowing Jagidari abolition. They were not allowing anything to be any welfare measures for daddies or poor. And they were allowing everything to be published in the papers. You know, there is Ramesh Thapar, the elder brother of Ramila Thapar. He was running a magazine class, Crossroads. It was banned in Madras. When it was done, within few months of adopting our constitution, we adopted our constitution 26th January 1950. The magazine was banned in March. He went to court. Why it was banned? Because the magazine carried a story about an incident where the police have killed 22 communists in Salem court, Salem jail. That's why it was banned. So he went to Supreme Court. Supreme Court did not take years as it is taking today. Within 3 months, on May 26th, it gave a judgment saying that Ramesh Thapar was right. He has got every right to publish what he published. Then there was another case in Delhi. This is Ramesh Thapar versus Madras State. There is another Dinopadhyaya versus Delhi State. Their organizer wrote a story on happenings in East Pakistan. That was also banned. The same Supreme Court upheld the organizer. So Nehru thought the days were different. In those days, in 1960s and 70s, 50s and 60s, the Supreme Court was acting as though they were safeguarding civil liberties. They were in the forefront of defending people who Nehru and others thought are violating the Constitution. So Nehru thought there should be some reasonable restrictions to press freedom. Ambedkar said there is no need for any separate article restricting press freedom because it is part of the freedom given to all citizens. So press also will have the same freedom. But Nehru thought in the interest of national integration, in the interest of friendly relations with neighboring countries, in the interest of social harmony, we should bring about some reasonable restrictions to be borne on the press. So he did not do it alone. It was not the only case. He amended many articles, including Article 19. As he said, Dr. Rajsekar said, he amended Article 15. He amended many more in 374, 376 also. But many aspects were there in that amendment. It was not only meant for suppressing freedom of the press. Freedom of the press was not suppressed actually because of that amendment. Because of that amendment, the Supreme Court and other courts were given an opportunity to see things as they are and give judgment more earthy way. That's why it was not objected to by any professional organization then. No journalist union has objected to that amendment.
So I won't tax you with what I wanted to say otherwise. కాన్స్టిట్యూషన్ మనకి ఇచ్చిన హక్కుల గురించి దానికి అంబేద్కర్ గారు చేసిన ఎఫర్ట్ని గురించి ఇప్పటి వరకు చాలామంది మాట్లాడారు. కాన్స్టిట్యూషన్ చెప్పింది ఏంటి, ఇప్పుడు జరుగుతున్నది ఏమిటి అనేది. ఎకనామిక్ ఈక్వాలిటీ గురించి ఐ వాంట్ టు స్పీక్ అబౌట్ ఇట్. ఎకనామిక్ ఈక్వాలిటీ ఎలా వస్తుంది? గవర్నమెంట్కి ట్యాక్సెస్ ద్వారా డబ్బు సంపాదిస్తారు, అది ప్రజల ఉపయోగం కోసం స్పెండ్ చేస్తుంటారు. ఇట్ కుడ్ బి ది పబ్లిక్ ఫెసిలిటీస్, ఇట్ కుడ్ బి ఇండివిజువల్ హెల్ప్ లైక్ స్టూడెంట్స్ బీయింగ్ గివెన్ స్కాలర్షిప్స్ ఎట్సెట్రా. Now, what is happening earlier, there was so much importance given to the reservations because there are many government jobs. But today, you hardly find a government institution advertising for new posts. And some of the states are clever. If some vacancies have to be filled, they are doing it on contract basis. So the government jobs are a disappearing species. Where are the jobs today? Now every sector is being privatized. It is just not education, it's not just health, it's not roads. Even the defense department activities are being privatized. So if the jobs are in the private sector, what is the purpose of reservation in government jobs? You are addressing maybe 5%, 10% of total jobs through reservation. Now for me, it looks as though we have to give a very totally different interpretation to the word reservation. Now how do the private industries function? How do they create wealth? Wealth in such a manner that 10% of the people in India own 90% of the wealth. Now they make that money by the industries, by various other things like in hospitals and schools, colleges. Now, can they do all this without government support? A school has to be permitted by the government. A hospital has to be licensed by the government. And then, if they want to export something, import something, they have to give permission. Government has to give permission. So, private sector can do nothing without support, without facilities, sometimes free. So the action now lies in asking for reservation in private sector. When some of us talked about it, they said we can't force the private sector to reserve jobs. It's their own organization. So it's not their own organization. It's an organization which is built by you, supported by you, the oxygen is coming from you. Now, natural resources should belong to everybody. That's what Ambedkar said in the Constitution. Now, can any private industry have activity without water, without land, without electricity? These are all public facilities which are helping them to start these things. So, now, Mr. Lakshmaya, myself, and some of the colleagues sitting here, we had taken up a movement for reservation budget sub-plan, and it started in combined Andhra Pradesh, and people like Mr. Ramchandra Murthy have helped us with the press to get a lot of publicity. Any poor man's meetings are not covered in the press, but because of Mr. Ramchandra Murthy and Mr. Lakshmaya, who was himself a journalist, all our activities were publicized, and then we brought a lot of pressure on the government. Finally, we had sub-plan materializing. Now, after Andhra Pradesh, now there are some other states which have taken up this, which Mr. Lakshmaya has already mentioned.